Good evening, everyone, and thank you for joining us tonight for the webinar, Green Card Options for Physicians. My name is Peyton Page, and I am the Physician Engagement Coordinator at Practice Match. I am here tonight with Elissa. She is going to be presenting, but I'm just going to give a few minutes before people log on and just note that microphones will be silenced tonight for you guys. However, you are welcome to put any questions in the Q&A, and we will both monitor that and answer them as they come in. Lisa, you can take it over whenever you're ready.
Great, thanks, Peyton. Hi, everybody. My name is Elissa Taub. I am an immigration attorney and partner at the law firm Siskin Susser. I also am the co-author of the Physician Immigration Handbook, which, as you can imagine from its name, is all about immigration for doctors. And tonight we are going to talk about green card options for physicians and really just do a pretty broad overview of how the various green card processes operate and some important things to know about them. Before we get started and kind of dive in, I just want to mention a couple of housekeeping things. As Peyton mentioned, I will monitor the chat and the Q&A. So if there's something that, a question that comes up, please feel free to put it in there and I'll try to answer them as we go while we're kind of in that relevant topic rather than waiting until the end. Also know that because this is a webinar, right, it's not a confidential private consultation. I won't be able to give any independent or individual legal advice to you. And on this call, that's not really the purpose. It's really just for informational purposes. But I also want to caution you not to share really, personal information in the chat during this webinar because it won't be confidential. So other people will see it besides just me. Okay, with that little introduction, let's dive in. So here's what we're going to cover tonight. I'm going to start off by giving you a short overview of how green cards work. What are they? What are the various big picture pathways and some important things to know about how our system of getting a permanent residence works? And then we're going to talk about 5 different pathways to a green card, starting with the most common, which is the perm-based EB-2 process, going through some other of the EB-2 processes, and then finishing up with a discussion of the EB-1s. And then at the very end, we'll talk about some important issues and pitfalls, things to consider as you're making a decision about which of these pathways to pursue or whether to pursue more than one pathway, which is also a possibility. So this is our, I think, there we go. This is our roadmap for the evening, and so we'll move forward. This slide kind of gives you an overview of how green cards are allocated in the United States. And we're not going to spend a ton of time here, but I think it's helpful before we just dive in and start talking about EB-2 to even just talk about what does that mean, right? Like what does that abbreviation stand for, and where does it fit into the overall scheme of things? So you can see I have on this screen an upside down triangle. And so, of course, when you turn a triangle upside down, the broadest side is at the top and the narrowest point is at the bottom. And this is to represent that they're at the top there, you see all green cards. And as we go down and this triangle narrows, we start to talk about more specific categories of green cards. So the United States limits the number of green cards it issues every year, and they're split up into various categories. And at a very basic level, they're split up into employment-based and family-based categories. So when you see EB-2, the EB stands for employment-based. It means that we're going for a green card based on some aspect of our job. When you see FB or F, like F2A, sometimes you'll see the F stands for family, right? And so that's how you immediately can tell if somebody's talking about an employment-based green card or a family-based green card. When you go further down the slide, you see that there are numbers. And what the government does is they created subcategories in the employment-based side and the family-based side, and they say, well, some of these are more important to the United States interest than others, and so we're going to rank them. On the employment-based side, they're ranked 1 through 5, and on the family-based side, they're ranked 1 through 4. And on the family-based side, we also have a category of people called immediate relatives. These are spouses of U.S. citizens and parents of U.S. citizens, and they are the only folks for whom green card numbers are uncapped. So the government can approve as many of those in a fiscal year as they want. All of the other categories, what EB 1, 2, 3, 4, 5, F 1, 2, 3, 4, all of those categories have limits. And then within each of those categories, there are subcategories. So for example, in EB2, there are 3 subcategories of applications. There are perm-based cases that are based on somebody having an advanced degree. There are national interest waivers, and then there are people who have exceptional ability in their field. And even we could drill down further, there are 2 different kinds of national interest waivers, right? So we kind of go down all of these levels. And so the idea is just to show you when you're applying for EB2, first of all, there's more than one kind of EB2. There's more than one kind of EB1. There are 3 different kinds of EB1 petitions. And so we just want to make sure that, my goal here is just to make sure you understand that there's some context to all of this. Okay. So you're going to hear me talk about some forms tonight. Some forms tonight that have to do with the various green card processes. So before we dive in and really get into the meat of how those processes work, we want to talk about the different form numbers and names so that we don't have to spend time later kind of rehashing that every time. If you're going to be filing an application based on perm, and we're going to talk about that in just a second, what does that mean? What is perm referred to? If we are going to be filing a green card based on perm, the initial step of that application is going to be filed with the U.S. Department of Labor, not with the Immigration Service. And that's filed on a form called an ETA 9089. And it's a fully electronic form. It's not something that gets filed on paper in most cases. You likely, as part of a perm application, would get to review a PDF of that form. But when we submit it, it's done entirely electronically. Once a perm is approved, or if you're filing through a process that doesn't require a perm, every single employment-based green card is filed initially. There is a petition filed with the Immigration Service on a form called an I-140. The I-140 has a million different boxes to check on it, and those boxes designate which I-140 category we are applying in. I'm having a little bit of technical difficulty with my screen, so I'm kind of have my presentation on 2 different screens. I'm going to stop my sharing and I'm going to restart it on the screen that's not blacking out, because I don't know if you all are experiencing that with me. So just give me a moment to fix that, because I think it's confusing. Let's see, we are going to this back down here. And we are going to start from the current slide, and we are going to this. Oh, goodness. There we go. Apologies that we are having this difficulty. That should not happen. Okay, so let's get. I'm hoping that that is being shared. Okay, so the form I-140 is, let me just do this again, because I feel like that didn't work. Apologies. There we go. Now we're good. Okay, so the form I-140 is filed anytime that we file a green card application based on employment. If you were going to seek a green card based on marriage to a U.S. citizen or to a permanent resident or something of that nature, the form that would get filed is an I-130, not an I-140. And we're not really going to spend a lot of time on those tonight because it's a totally different process. And we won't have time to cover both, but just know there is a difference in the form that is filed for employment-based versus family-based. And then when you actually seek your green card, you're going to file something called a Form I-485, which is also known as an application for adjustment of status. And that's the application that will ultimately lead to the issuance of your green card. And you might also include with that an application for a work card, and an application for something called advanced parole, which is travel authorization. And so though these are the different forms that are going to form the basis of your employment-based green card application, or potentially will cover that. And for each process, we're going to talk about what the effect of these different forms are, and some special aspects of them. So let's go forward and talk about the EB-2 perm labor certification process. By far, this is the most common process that I work on in my office, and I think that most immigration lawyers who work on employment-based cases or work with employers do a lot of perms. This is really the default pathway to a green card under the law. The Immigration Service, the U.S. government, wants employers to show that they can't find an American worker for this position who is qualified and available and interested before somebody gets sponsored for a green card by their employer. And that's what the perm does. The perm process is regulated, as I mentioned earlier, by the U.S. Department of Labor. It is not regulated by USCIS. And it is probably the longest, most tedious, frustrating preliminary process that any government official ever made up. What happens during the perm process is that we actually have to advertise your position to test the relevant labor market to show that an American worker who's qualified, available, and interested, we can't find them, right? There's nobody responding to our recruitment, or maybe the people who respond aren't qualified. We've had people respond to recruitment who weren't even doctors, but they were collecting unemployment and they needed to submit resumes, and so they did, right? So it's just a very long process. The first thing we do as part of the perm is we're going to file something called a prevailing wage request with the Department of Labor so that they can make an official determination on what the minimum wage that can be paid for that job is. I can look that up in about 2 minutes. The Department of Labor is going to take right now about 7 months, 6.5 to 7 months to tell us what that wage is. Those processing times fluctuate all the time. Earlier this year, we were at about 4.5, 5 months. Now we're closer to 6.5 months, maybe 7 months on prevailing wages. A couple of years ago, they were at a year. 5 years ago, they were at 90 days. So you can see that processing times on prevailing wages are all over the place. And the problem is we can't speed them up. So we file it. And, in the meantime, in my office, at least, in the meantime, we kind of set certain timeframes to handle the process. And so while the prevailing wage is pending, we'll start doing the advertising in the case and try to get through most of the steps in the application so that when the wage comes back, we're ready to file. We're able to do that because we do feel comfortable that all of our physician clients are earning at least the prevailing wage. If we were working in a field where maybe that wasn't the case, right? If I were working mainly with software people or accountants or other professionals where maybe there's wild fluctuation in wages in a particular region, I might want to wait until the wage is issued before I undertake the rest of the case so that I know that what we're dealing with is appropriate, right? The other thing to know is that from the time we start recruitment, we have to get it all done within 6 months, and we have to file the case within 6 months. So I can't start the wage too early because start the recruitment too early, because if the wage doesn't come back for 7 months and I start recruitment at month 1, everything's going to expire by the time the wage comes back, and I'm going to have to redo it all at great expense to your employer. So we manage and monitor all of those timeframes in our office, and that's why it's really important for an immigration attorney who knows about perm to handle these cases. There are a lot of really weird, counterintuitive rules that come up with perm. They can be extraordinarily complicated. Thankfully for me, perms for doctors aren't that complicated in most cases. Because there is a physician shortage in this country. We don't get a lot of responses to recruitment. We don't have to be too careful about how we describe the job duties and all of that because everybody's a doctor. So we tend to get these cases are a little bit easier, at least in terms of the mechanics of them, than maybe it would be in a different field. Once we file the perm, and I would say they take about a good 8 to 9 months to put together. Most of that time is taken up with waiting for the prevailing wage to come back. Once the perm is ready to be filed, as I mentioned earlier, we submit it online to the Department of Labor. It is a relatively quick process to submit it, although like I go through and I review all the aspects of the application before I submit. And once it's submitted, it's taking a good 13 months for these things to get approved. I've one case pending since June of last year. I've got a bunch of cases pending since July, August of last year that we still haven't heard on. There is no premium processing. There is no congressional inquiry. There is no way to expedite the perm labor certification. The Department of Labor's processing times are what they are. Where we can take a little bit of control over the process is once the perm is approved, then we're going to take that and we're going to take all of your credentials showing you're qualified for the job. We're going to submit your employer's financial information to show they can afford to pay you. We're going to submit that to the Immigration Service along with that Form I-140. The I-140 is going to show that there is an approved labor certification for the job. Your employer wants to hire you for that job, and they can afford, you're qualified and they can afford to pay you. So we submit all that as a very straightforward petition, and that can be filed with premium processing. So once the perm is approved, we can speed up the I-140 pretty significantly. And if you don't have a current priority date, if your category is backlogged, which for pretty much everybody, EB2, EB3, all backlogged for everybody, it's just a matter for how long. We will have to wait until you have a current priority date to be able to file the last step, which is that I-485, right? But we can get at least through the point of filing that I-140, get that approved. The I-140 approval has a couple of important benefits. The first thing is that in this type of green card application, your priority date is the date on which we file the perm with the Department of Labor, and it locks in when the I-140 is approved. So the I-140 approval makes your priority date permanent to you. Your priority date is your signal in the long green card backlogs about where you are in that queue, right? When we look at the visa bulletin, we figure out when people are eligible to file that last step of the green card application. We're doing that based on the earliest date upon which an application was initiated for them. So for these cases, that is the date the perm is filed, which means that if the perm is taking 5 months to be approved or 12 months or 14 months to be approved, the priority date does not change. It is still the day on which the perm was filed. And the I-140 approval locks that into you and makes it permanent to you so that if you were to change jobs later on, or your employer has a reorganization or something like that, you can always recapture. You always go back to that initial priority date. The other thing that I-140 does is if you're in a backlogged category, which pretty much everybody is right now, you can have your H-1B extended 3 years at a time until your priority date is current and you can complete green card processing. So you get an additional benefit of that out of that I-140 approval. And that ability to get those additional extensions not only applies to your existing employer, but also to future employers that might file for you. So that is a really important benefit, especially at a time right now. As I mentioned, everybody is experiencing green card backlogs regardless of where you're from. And so those benefits become really important. As I mentioned, this is the default position. The basics are that, if you are going to seek a green card, your employer is going to have to go through this process. It is not the only process. And I should mention that for those of you who are completing J-1 waivers, the perm and I-140 can happen during your 3 years of waiver service. But even if your priority date is current, we cannot file Form I-485 until you complete your 3 years of service. That is true for pretty much every single one of the processes we're going to discuss tonight, with one exception, and I'll point that out when we get to it. But this is the standard. Now, let's say your employer offers to go through this process and you decide that there's actually a different process that we're going to talk about tonight that you would rather do. But your employer says, look, I'm only going to do this one because I know I have to pay for this and I have to sponsor this. Anything else, if you want to do your own green card application, you're on your own. Just know you're not limited to only one process. You can have multiple different green card processes going on at the same time. Now, at the end of the day, you're only going to get one green card, and it doesn't matter which way you get it, right? All of these employment-based green card processes are going to give you a 10-year green card. You'll be eligible to apply for citizenship 5 years after you get that green card. There's nobody gives you any kind of special prizes or anything if you get an EB1 versus an EB2, right? Like they're all the same green card. But EB1 and EB2 may have different backlogs. You may find that one type of process gives you more job flexibility than another. So there may be reasons to jump back and forth between processes as you go. And as I say that, one thing to note about the perm process is that it is specific to your employer, your position, and your location. And if any of those things change during your employment or during, before you get your green card, the likelihood is that that process has to start over. Now, you don't lose your priority date if that was already established for you, meaning you have an approved I-140. But if your employer files a perm for you and it's pending and you have to change jobs unexpectedly, there's a layoff or something, you have no priority date. That perm is not going to be usable unless you're later on in the future going to go back to that job, because this is all a forward-looking process. These job offers that form the basis of a perm are about the job you will be in when you obtain your green card, not about what's happening today. So it's important to know how future job changes can impact a perm application. And it happens all the time, right? There are a lot of folks who are stuck in very lengthy green card backlogs because they were born in India. The green card backlog is going to be more than 10 years, maybe 15, 20 years or more, depending on how things go. And so it's conceivable that you're going to change jobs within that time period, right? And you may have to have successive employers go through this process for you. The most important thing to know is that that first priority date, the earliest one that is locked in, is permanent. You don't lose that. You don't go back in time each time you have to go through this process. So that is the perm process. There are, with each of these processes we're going to talk about tonight, there are a lot of details that we are not going to have time to go over, right? I could do a whole hour just on perms and how they work. So we're not going to be able to get like super deep into these and all the little details. But I wanted to spend a little bit of extra time here because it really does form the basis of a lot of other processes. Okay. So the next process I want to talk about is the EB2 Physician National Interest Waiver, or what we refer to as a PNIW. The PNIW, people get confused between this and a J1 waiver because they both have the word waiver in them. The most important thing to know is that for a PNIW, what's being waived is the need to do the perm. With a J1 waiver, what's being waived is the 2-year home residence requirement. So even though they both say waiver, they are not the same thing. They don't waive the same thing. A PNIW is not a substitution or alternative to a J1 waiver. If you're doing if you did your training in J1 status and you don't get your first choice of J1 waiver, you can't say, oh, I'll do a PNIW instead. You need the J1 waiver. The PNIW is a green card process, and that is all it is. It doesn't have anything to do with the J1 stuff. What the PNIW says is that if the physician agrees to work 5 years in an underserved area, Congress determined that that is important enough to the United States. They created this special green card pathway. You can apply anytime. You can apply on the front end as soon as you sign a 5-year contract. You can apply in the middle of the service, or you can apply when the service commitment is complete after the 5 years. Under any of those scenarios, your green card should not issue until those 5 years are complete. Everybody, if you Google this and you talk to people, you might hear about cases that have been prematurely approved, where somebody gets their green card after 2 years, and those are kind of messy. We have to unravel the whole thing because that green card is not really valid until you finish the 5 years. One of the nice things about the PNIW is that the physician sponsors themselves for the green card. You need your employer's support. There's documentation they have to provide for the process, but they don't have to sponsor you and they don't have to pay for it, which gives you as the physician a lot of control over this process. The other thing is that unlike the perm process, which is very specific to employer, position, and location, the PNIW doesn't matter. You can, change jobs and take the benefit of this petition with you. So you could do your 3 years of J1 waiver service with one employer, and then after that, finish up 2 years somewhere else. you likely have to file an additional I-140 to notify the government that you've moved, but you don't start from scratch, right? You get credit for all of the time that you have worked. So there are some really great mobility benefits to the PNIW. The other thing I like about it is that in most cases, we can file an I-140 for this. We go directly to the I-140 pretty much. We can file it a lot faster than we can file a perm in most cases. So you can save several months in priority date by going with the PNIW. The way that this process works is there needs to be a government letter of support saying that your work in the underserved area is in the public interest. That letter typically comes from the state, from the same office that does J1 waivers. If you go through the DRA or the SCRC, those agencies also will support PNIWs. HHS, the NBRC, and ARC, which are other federal J1 waiver agencies, they do not do PNIW support letters. So if maybe you got a J1 waiver through HHS, you can do a PNIW, you just have to get the support letter through the state. And that's usually not a problem. States are not limited in the number of those letters they can issue, but they all have their own rules about when they will issue it, which kind of service they'll take notice of. For example, if you do your training in H-1B status in New York, the state of New York will not let you get NIW credit for your time spent in training there. They will only count time spent as an attending in the state when they give out one of those public interest support letters. So they all kind of make up their own rules, but that's the first step. And once you have that public interest letter, then you can file the I-140 and get that shipped off to the Immigration Service and establish your priority date. A couple of years ago, USCIS made premium processing available for PNIWs. That's been amazing. Prior to that, it was taking 13 to 15 months to get those cases approved. Now most of them are getting approved within a couple of weeks. So it's a really fantastic option. Because there's no perm here, your priority date is established on the day the I-140 is filed and locked in when that I-140 is approved. So as I mentioned a couple of times already, PNIWs are a much faster way than perm to establish a priority date and have it become permanent to you. Maybe get that approved I-140 to make you eligible for additional H-1B extensions. So there are really good benefits to doing the PNIW. That said, they're not right for everybody, right? You've got to spend 5 years in an underserved area. Maybe you did your training in H-1B status and you never worked in an underserved area. Maybe you do your J1 waiver status and you're like, no, I don't want to do that anymore. I want to get my green card based on perm. That is totally fine. That is how most of my clients get their green cards, but we do a lot of PNIWs. One of the other nice things about a PNIW in terms of timing is if you have a spouse who's going to be in H4 status. Initially, H4 spouses cannot work in the United States. They need their H-1B spouse to have an approved I-140 in order to apply for an H-4 EAD, which is a work card that H-4 spouses can get to let them work anywhere without sponsorship. One of the really great things about being able to premium process PNIWs is that we've been able to get those for doctors early on in their careers, and it allows their spouses to work at a very early point. I'll give you a great example. In the last year, we've had a couple of J1 doctor clients. We've done their J1 waivers, and at the same time that we pursue the J1 waiver, we also pursue support for an NIW. This means that the doctor up front is signing a 5-year contract instead of a 3-year contract. We get the J1 waiver and NIW support letters at the same time, and we turn around and we file that I-140 with premium processing. USCIS approves it. And then when we change the doctor's status from J1 to H1B so they can start their waiver job, and we change the spouse's status from J2 to H4, we also can file the EAD application at the same time. And all 3 of those applications get approved at the same time. And so the spouse can start work at the same time as the H1B spouse. It works out really beautifully. So we've done this a few times in the last couple of years since we've been able to premium process the PNIWs. With perms taking so long, there are sometimes strategic reasons why we'll file the PNIW. In the meantime, the doctor's employer might agree to do a perm, and that may be ultimately how they get their green card. But there's nothing wrong with pursuing both options at the same time for strategic purposes. I guess the important thing there to note is that, as I mentioned before, your employer might not pay for the PNIW. So that may be something where you have to, pay out those fees out of your own pocket to get that benefit for your spouse, right? But there's a really great, there are other strategic uses of the PNIW. So it's a really fantastic option. Not right for everybody, but it's a really great option if it works for you. Now, you might be saying and thinking in the back of your mind, I've heard that there's another NIW that is based on maybe somebody doing research or doing something important for the government. And you would be right. There is a second kind of NIW. We immigration lawyers refer to it as a Danisar NIW because there's a court case called Matter of Danisar. We also sometimes just call it a regular NIW. But basically what this is a green card application that a person can sponsor themselves for that is based on their doing work that is in the national interest of the United States. The work in itself has to have what's called substantial merit, meaning that there's some, intrinsically, there's something important about it to the country, that it's a nationally important work. It's not just something that benefits a local community. And the person who's applying has to be well positioned to advance that work. In other words, they need to be in a situation where they have, plans for how they're going to carry out the work, that they may have a job that is where they're doing the research or whatever the work is. So there are lots of different ways that we can use the NIW. Oh, I guess, and the last part of that is that it wouldn't be fair to the employer to make them do a perm to find somebody who's minimally qualified when they have somebody like the applicant who is really maximally qualified, right? Who's really doing important work and has all the best credentials. The nice thing about the Danisar NIW is that for somebody who's done a lot of research or who's maybe working in a very high profile medical center where maybe people travel from all over to come get treated there because it's a national center of excellence for a particular type of treatment, these can be really great. I will say when it comes to folks who are pure clinicians with no research background and who are maybe working in community hospitals in rural areas, we're going to go maybe look at the PNIW over the Danisar NIW. I don't do a lot of them for clinicians. I did one last year for an anesthesiologist who was working at a big academic medical center who was very high up on some research projects, and that got approved, which was great. The other thing I should mention is that right now USCIS is on a tear issuing requests for evidence on these cases. Over the years, getting these approved has not been as huge a lift as maybe an EB-1A, we'll talk about later. But lately, there have been RFEs coming like crazy. And we think USCIS noticed that their approval rates were too high, and they're trying to pull back on that a little bit. That seems ridiculous to me, but whatever. So just know, if you talk to colleagues who are like, oh yeah, do that Danisar thing, it's easy, everybody gets approved. That might not be the case right in this moment. This might not be the best time to apply for one of those, but they can be really great options. And again, just like with the PNIW, your priority date here is established on the day the I-140 is filed. It locks in when it's approved. You can premium process it. So there are good benefits there as well. One thing I did forget to mention with the PNIW is that is the only exception to the rule that a J1 waiver physician has to wait until the end of their 3 years to file an I-485. The only exception to that is a PNIW. As long as you have a current priority date, you can file an adjustment of status application based on that type of application, even during a physician's 3 years of service. Before the EB2 category became backlogged for everybody, we did that all the time. Over the last several years, we haven't been able to because of the backlog, but it can be an option if things free up again. But this type of NIW, the Danisar NIW, does not benefit from that same exception. They are two different types of applications. Even though they are both EB2 NIWs, the exemption that allows a physician to file an I-485 during the 3 years of J1 waiver service doesn't apply. It doesn't exist in the Danisar section of the rules. So just keep that in mind. They are different in very key ways. Okay. We're going to switch gears and go from EB2 to EB1. I know that in talking with physicians, in fact, I just had somebody contact me today and say, I really want to know about EB1. There are three different kinds of EB1s. One of them is the one you see on your screen now, which is EB1B for outstanding professor or researcher. There's EB1A for people who have extraordinary ability in their field, which we'll talk about next. And there's EB1C, which are for multinational executives and managers. We almost never do those for doctors, right? Those are used by folks that are moving from another country to the US to take a managerial or executive role where they previously worked abroad for the same or related company. So that is not what we're going to talk about today. We're not going to get into EB1C, but we will talk a little bit about EB1B and EB1A. So the EB1B, outstanding professor or researcher, is in the EB1 category, but it's actually an employer-sponsored process. The PERM is an employer-sponsored process. The NIWs waive that PERM requirement. They can be filed by an individual. EB1A can be filed by an individual, but EB1B is employer-sponsored. It's really important to understand that because I get asked about it all the time, and a lot of folks don't realize that, and they don't realize that there's a difference between EB1A and EB1B and how that works. The EB1B, it has to be sponsored by somebody who is working in a tenure track or full-time research position at either an educational institution or a research institution. Your local community hospital cannot support EB1Bs. Your hospitalist staffing company typically cannot support EB1Bs. They don't conduct enough research to be eligible, and the likelihood is that you are not going to be working in a full-time position as a hospitalist working for a staffing company. So it's important to know there are limitations on, it's employer-sponsored, and then limitations on the types of employers and the types of positions that qualify. So even if you have an academic appointment, maybe you're working as a hospitalist at a medical center, and you have an academic appointment as part of that, you would need to be sponsored by the academic institution, not the staffing company. And you need to be able to show that it's a full-time research position where you're doing like a fair amount of research. And there are some other requirements in there as well. So most of the time where I have a hospitalist that is working in a, small, in a medical center like that, we're going to be doing a PERM or maybe a PNIW, but the likelihood of us doing an EB1B is pretty small. The important thing here is to know that in addition to your employer qualifying and that the position qualifies, the individual also has to qualify for EB1B. And then you have to show that you're outstanding in your field. So there are a list of 6 criteria in the regulations, and you have to meet at least 2 of them. If you're well published, if you've won awards, if you hold leadership roles, those kinds of things, meeting those 2 criteria is oftentimes not terribly difficult. I find that on these cases, the hard part is making sure that we're proving that the position and the employer qualify, not so much that the physician does, but they can be really great options because they get you into EB1, right? Where if there is a backlog, it's much shorter than EB2. And unless you're from India or China, there is no backlog in EB1. So it can be a really great option if you're in the right position to make it work. Even though your employer has to sponsor an EB1B, they don't have to pay the fees. So it is something you could say, look, if you'll do this for me, I'll pay for it. If there's a negotiation going on with them, you can premium process these. I usually, for the EB1s, do not advise to concurrently file an I-485. So even though if there's might not be a backlog for you, and you could file the I-140 and the I-485 at the same time, because these petitions are highly subjective, I do not recommend doing that. I recommend filing the I-140 first with premium and then getting that approved, and then moving on to the I-485 once you know that that's going to go forward. And then we do that with EB1As as well. And I'll talk about premium processing in just a second when we get to that slide. So EB1B, personally, I don't file a lot of these. My office does, I don't, because I find that most of the physicians that I work with are really strong clinicians, not necessarily academically inclined. And so this just doesn't work out. A lot of my clients, my employer clients, can't support these. So I don't do a ton of them, but for the right folks, this is a great option. I will mention, academic institutions typically have policies and procedures for who they will support for these types of petitions. So it's something that if you were interested and you are in academia, you would definitely need to talk to your students and scholars office, whoever it is in your institution that would manage this stuff, because just because you work there doesn't mean that they will automatically sponsor you. There are requirements. And on the perm side of things, there is something called a special handling perm for somebody who teaches in an academic setting in a university or college or medical school. So you may be in a situation where your academic institution says, well, we'll do a special handling perm, which tend to come out a little bit faster and have different rules to them rather than an EB-1B. So that may be a conversation that you need to have with them. Okay. EB-1A. So as I mentioned, EB-1A is for individuals who have extraordinary ability in their field, and it's a process that you can sponsor yourself for. You really don't need anything from your employer to make that happen, other than maybe a letter of support. It is, how do I explain this? EB-1As are challenging applications. You have to show that you have extraordinary ability in your field, which is defined as somebody who has reached the very small percentage of people who are at the top of the field. The regulations set out 10 categories of evidence. You have to meet at least 3 of them comfortably in order to get the application approved. And when I say that you have to meet at least 3 of them comfortably, what happens is the government's going to look through and they're going to say, do you meet at least 3 of these categories of evidence? And if yes, if we sit back and we look at this application, does this person really seem extraordinary? Do they seem like they're at the top of their field? So if you meet just 3 categories of evidence and you do it by like a very little amount, the likelihood is that the Immigration Service is going to issue something called a notice of intent to deny, where they give you 30 days to respond and show them why you are extraordinary. And they'll say, yeah, we agree that you meet 3 of the categories, but we don't think that you seem like somebody who's at the top of your field. And we do see those, and we see them in the EB-1B context as well. So when I take on an EB-1 case, I want to make sure that not only do I have at least 3 categories that are comfortably met, I want to argue as many categories as I can, because also the Immigration Service doesn't have to agree with us that you meet the 3 categories we put out there, right? So if I only say you meet 3 categories and they find that you don't meet one of them, the case is over. So we want to argue 4, 5, 6, 7 categories, as many as we possibly can. And note that out of those 10 categories, 2 of them really are not readily applicable to doctors, right? There's one about displaying your work in an artistic exhibition or showcase, and there's one about commercial success in the performing arts, like box office sales and concert ticket sales and things like that. So right off the bat, out of the 10 categories, you really are talking about 8. I should also mention that in addition to those 8 categories improving 3, if you have some kind of big major international award, like a Nobel Prize, yeah, that can do it all by itself, but those are really rare. And even when we have somebody who has won some kind of major prize, the Immigration Service usually tries to argue with us about why it's not. So I assume that none of you on the call tonight have a Nobel Prize. If so, please email me because this will be really easy. But at any rate, just as with the EB-1Bs, I usually recommend not concurrently filing the I-140 and I-485. The thing about EB-1As, and I was actually talking with another lawyer in my office about this today. We got one approved today, which we're very excited about. We filed it. It was a very strong case. The person was an artist, a performing artist, not a doctor. But when I met with him the first time, and I heard about all of their evidence and I saw them perform and I was like, yep, this is it. I know it when I see it, we're going forward. We filed a very strong case. And we got a request for evidence that was just ridiculous, right? We don't meet any of the categories. not really, totally misconstruing and misunderstanding a lot of the evidence that we submitted. This person has been on TV shows that are household names and all of this stuff. And we were just shocked. So about last week, we filed the response to the request for evidence. And today we got the approval. And I tell you this story, first of all, I'm really excited we got the approval, but also to illustrate for you, this happens a lot. EB1As, the Immigration Service is skeptical. They think everybody's lying about their achievements or misconstruing their achievements. And especially with Indian national doctors or researchers who normally would go through EB2, they assume that nobody would file EB1 without the backlog. And so therefore you couldn't possibly be qualified, which is not the right analysis and isn't anywhere in the law, right? So we have to go into these cases with a healthy dose of skepticism, try to play devil's advocate on a lot of our arguments to try to bulletproof them so the Immigration Service can't come back and deny. But they do deny these. They deny them. I think about 30 to 35% of these cases are denied every year, maybe more. They are very, very challenging. So today, somebody contacted me and said, I really would love to talk to you about EB1. All of my friends have done it and they said I should do it too. Well, that's not really important to me, right? That's irrelevant to me. What I need to know is whether this person qualifies. What is, and not just by looking at their CV, but actually having a conversation with them to go over the CV and ask them probing questions to find out what types of evidence they actually have. And I'll literally go through the categories of evidence with them in that consultation to decide, how many do we have, right? We'll count them up at the end. How strong do we feel they are? And there are times where I will say, we got it, let's go. And there are other times where I will say, you're not ready yet. Here are some things that you can do to make your case stronger. Because the last thing I want to do is take on a case that, it's not that I won't take a case that is not a slam dunk, right? And who even knows what that is these days, but I don't want to take on a case that I know is less than, that in my experience is not ripe to get approved, and have you believe that it is, right? And so then we go through the motions and we file it. You're really excited. We're biting our teeth. We're biting our nails saying, I don't know if this is going to work out. And then everybody's upset in the end if the case is denied. That's not to say that USCIS doesn't deny strong cases, but I would rather be on that side of things than have a weak case denied. So I would rather you take the time to get your affairs in order, make sure that things are as strong as they possibly can before we dip our toe into these waters, because these cases are really challenging. And they take some time to prepare. Because the Immigration Service is harsh on these cases, they are very subjective, meaning that it's going to be the individual officer and their personal opinion of your case that are going to carry the day. We don't know who they are. We don't know their names. We don't know their own personal biases that they bring to this work. And that's true of all of these cases. So we want to make sure that before we go forward, right, we make the case as strong as possible. That also takes time. So I don't want to make it sound like I'm dissuading you from doing EB1A, but I always find that these presentations are a good opportunity to provide some education and guidance on when it's appropriate to seek these. The other thing I'll tell you is, we sometimes have Indian national clients who, are looking to EB1 because the backlog is so much shorter than in EB2. It's actually like realistic to believe you'll get your green card through EB1 someday. What we'll do is I'll say, look, if your employer is going to sponsor you for EB2, take it. Don't say no, because we don't know how an EB1 is going to come out. And you want to make sure you have a priority date established. You want to make sure that you've got that covered. You want to make sure you get an I-140 approved if we need to do extra H extensions in the future. And then you kind of have time to work on the EB1. There's no rush. There are years and years and years of backlog ahead of us. And if we can get your green card for you earlier than that, it's a win, especially if we put in the work to make the case strong. So there are lots of different ways to think about EB1A. And so I hope I've given you some food for thought on that. Let's talk about some important issues and some pitfalls that we see. Some of this we may have already talked about, but I want to talk a little bit about each of these three categories that are on the screen right now. The first is with regard to backlogs, and we just talked about that a little bit. But to me, the most important thing for everybody, now that we are experiencing green card backlogs in almost every single category for every type of person, no matter where you are from, no matter what type of job you have, establishing a priority date, whether it's EB2 or EB3, depending on the background, is super important for everybody. I have been warning employers that physicians are going to start asking for sponsorship earlier than they ever have before, because now this is important to everybody, not just our Indian and Chinese colleagues. In fact, I'm going to be speaking with a group of physician recruiters on Monday, and that's part of my presentation, is to really do a deep dive with them on the green card backlog so they understand why you might be asking for sponsorship earlier than you otherwise might have. As I alluded to on the last slide, if you establish a priority date in EB2, it can be used for another category like EB1, another I-140 category. If you have an EB3 priority date, maybe your spouse does, they can use it towards something else. So you have flexibility there, and that's why I say, like, have your employer establish that EB2 priority date for you. Then if a few years go by, we do an EB1 petition and that gets approved, you already have that EB2 priority date. You might get your green card a lot sooner than you're expecting. It is a really great strategy. I've done it over and over and over again with folks, and it works out really well. The U.S. Department of State is the keeper of the green card backlog. They are the ones that do all of the accounting to determine how many visas are available in each category every year, and what the cutoff priority dates will be. And they do that on a monthly basis. And this is a very timely presentation because the new federal fiscal year will start on October 1st. That's when all of the green cards for fiscal year 2025 will become available. And we expect that the October 2025 visa bulletin is going to come out this week, probably Friday, but we don't know, but any day now. And I check every day because I do write-ups of it and everything. You can check the visa bulletin to see, where your priority date fits. There are lots of charts. I sometimes do another one of these presentations where we go and do a deep dive on the backlog and go through the visa bulletin. And I can show you kind of how to read the chart. But it's important, I think, for you to be able to follow that on your own and understand like where things are going. I don't know where things are going to be as of October this year. As I mentioned, we're waiting. I think the EB2 backlog won't go away. The EB2 worldwide backlog is likely going to be with us for this foreseeable future, but I do expect the date to move forward on that. And I do expect the India and China dates to move from where they are now. How far they will move and whether they will get ahead of any point that they were this past year, I don't know. I think for India, we're back in 2012 still. I really do hope it gets to move forward. One thing to note is last year, the State Department was really, really conservative for the first quarter of the fiscal year. So from October through December, the visa bulletin barely moved because they were monitoring usage, right? They wanted to see what demand looked like. They wanted to know, if there was going to be huge demand, then they were going to slow things down. If there wasn't that much demand, they can move things forward. And that's what happened in January of 2024. They moved things forward in a much bigger way. I think they might be doing the same thing this fall, but I don't know. I'll probably have more information on that by the end of next month. But I'm a little bit of a geek on the visa bulletin, so as you can probably tell. But we're really interested to see what comes of this October visa bulletin. All right, changing jobs. As we mentioned earlier, perm cases are specific to employer, position, location. That's true of all your employer-sponsored cases. Let's say, your employer does a perm for you, I-140 is approved, priority date becomes current, you file that I-485, it's in the system, you get an offer to change jobs. When the I-485 is out there and pending for 180 days, you can port to a new job in the same or similar position and take the benefit of that application with you to the new job. Until then, you lose it, right? But once the I-485 is pending 180 days, you can port. The way you do that, there's a form called an I-485 Supplement J, and that gets filled out by the you and the new employer, and it gets submitted to the Immigration Service to notify them of your portability request. Typically, the Immigration Service will approve that and the I-485 at the same time or within close proximity to each other. Let's say you have plans to leave your job at the time that portability attaches to you, and lo and behold, your green card gets approved faster than you expect. So instead of maybe the I-485 taking 7 months, it takes 4 months, and you're supposed to be changing jobs at the 6-month mark. What happens then? And your employer has sponsored you for the green card. It's a little tricky, right? Because as we talked about earlier, the green card process is based on a future offer of employment for when the green card comes. So the expectation is that when the green card comes, you are going to work for that employer for a reasonable period of time. What does that mean? I don't know. There is nothing specific in the law that says what that is. I usually tell folks I'd love for you to stay for a good 4 to 6 months after your green card issues. Just to be clear, later on, if you apply for naturalization, that this was a legitimate job offer, you legitimately intended to work for that employer. If you need to leave sooner, is that going to kill your chances of becoming a U.S. citizen? Probably not, but it could open you to questions about what your intent was when you sought the green card, and what the circumstances were that caused you to leave so quickly after the green card was issued. So that is certainly something that I would recommend talking to an immigration attorney about if that comes up for you. And then finally, we talked a little bit of those what we call AC-21 H-1B extensions based on having an I-140 approval. Because a person can only spend 6 years in H-1B status as an initial matter, I recommend that a green card process of some type be started for you no later than the end of your 4th year of H-1B time. And with perms taking as long as they are right now, almost 2 years, I almost have to back that up and say sometime in year 3, you really want to have a green card started for you so that you have enough time to get through the perm and I-140 process before you get to the end of your 6 years. If your perm or I-140 is filed for you at least a year before the end of your 6 years, you can get at least a 1-year extension of your H-1B time beyond the 6 years. And if you're backlogged and the I-140 is approved at any time before the end of those 6 years, you can get those successive 3-year extensions. So there's a lot, as we talked about earlier, the benefits of having an I-140. There are benefits to talking with your employer and having that process start on the early side. And as I've mentioned a few times, because the DANISAR NIWs, the EB-1Bs, the EB-1As can be subjective and aren't guaranteed to be approved or maybe have a lower likelihood of approval than some of the others, I would not, if a perm process is offered to you, I would not necessarily say no unless you want to go work 5 years in an underserved area, because PNIWs also have a high percentage approval rate. So those would be sort of your most reliable processes. And then the other more subjective processes that are based on your extraordinary ability, your outstanding work, your working in the national interest, those kinds of petitions, those I put almost as backup plans if you, or you only go to if you don't have another option, just because they're less calculated to be easily approved. And of course, all of that with the caveat depends on your background. I wouldn't necessarily make those decisions straight off just based on this webinar. You certainly would want to talk with an immigration attorney, talk with your employer about what options are available to you. But I hope I've given you some things to think about, have clarified, maybe busted some myths about some of these processes, and kind of given you some basis upon which to move forward. This is my contact information. If you go to our website, there's a place for you to click and make a consultation appointment. You're welcome to email me. And I wish you all the best in your green card processes.
Alrighty, thank you. At this time, if there's any other questions, I did see a question on here pop up earlier. They wanted the copy of this PowerPoint. A recording of this will be sent out to you guys later this week, and then it'll also be posted to the Practice Match website as well. So you guys are going to be able to go back and look at the recording. There's also a lot of other webinars that we have done with Elissa on there as well. So if there's any other questions, we will take them now. Okay, I'm not seeing any other questions pop up, but if you guys have anything that you think about later, feel free to email Lisa or myself. And like I said, this will be sent to you guys later this week. All right, thank you all for attending, and thank you, Elissa, for presenting.
My pleasure.
All right, have a good night, everyone.